Welcome to Unmatched Real Talk. Today's guest is Gabriel Saade, a well-known, trusted legal voice within the industry. Gabriel helps owners and operators through everything, from evictions to disputes to contracts to compliance. Let's dive into the legal side and welcome Gabriel.
Thank you, Sanya. Thank you very much for having me here. It's a privilege and a pleasure to be here with you, and it's good to see you again.
Absolutely, likewise. So please share a bit about your legal background and the industries that you serve.
Yeah, so I have been an attorney. Oh my God, it feels like forever at this point. About 11 years now, since 2014. I'm based in Florida, licensed in 10 states. So I service the legal industry in Florida, Georgia, Texas, Colorado, Massachusetts, the state of Washington, D.C., New York, New Jersey, and Utah. Those are the 10 states.
Wow, congratulations.
We actively litigate and practice and serve various clients in the different areas of law that we govern and practice within, primarily within hospitality, corporate, transactional, and we help developers, multifamily operators, construction companies. So essentially, what we try and be is that one-stop shop for business owners and business individuals for you to form, create
Mhm.
your business, to operate your business, and everything in between. And if you need to litigate, whether you're on the plaintiff side or the defense side, we can also litigate. So we've been doing commercial litigation as well throughout the country.
Congratulations.
Thank you.
So, a little bit about we're going to go into the common legal issues that you tend to see in the multifamily operators. What would you say that they face when it comes to compliance or residence disputes?
Yeah, multifamily operators, they're in the unfortunate, unique position of serving an industry where typically the tenants themselves are those individuals you want to serve. They're the backbone of America, right? These are our workers. These are the people that we rely on to build. And so there's a certain level of respect that you as an owner and an operator have to have. And similarly, the governments do too,
Hmm.
right? And specifically, even locales have very specific nuanced rules and regulations that govern tenancies and multifamily tenancies, depending on the zone, depending on whether the owner or developer received any corporate funds, excuse me, any public funds,
Hmm.
right? Where they benefited from some of those particular zoning areas that allow them to build and benefit from it. And so operators have to be in tune with their locale. They have to understand that if I'm accepting public money and public housing, how is that going to affect how I operate, how I can evict, what notices I need to provide, right?
Hmm.
So there's a very particular rule now that we're dealing with in Miami-Dade County that became into effect earlier this year, where notices for any operator that is operating within an industry that received any government funds, instead of the 3-day notice that you and I are used
Hmm.
to dealing with, and that is common under Chapter 83 of the Florida statutes, it's actually a 30-day notice if that particular project accepted any corporate funds, right?
Okay.
So understanding the nuance so that you don't get in trouble, because the way that evictions work, the way that operating these businesses work is it's very statute specific. So it's not hard.
Right.
The rules and the guidelines are written for you, but you have to read them and you have
Hmm.
to know them. And they're not static, they change, they're
Hmm.
organic. And as they change, you need to change with them and you need to understand, okay, here's the right way of doing it. And if you don't do it the right way, because it's so well laid out for you, you're going to get penalized for it.
Yep.
So if you send a 3-day notice to someone that should have received a 30-day notice, you're going to have to start again. So I think that is the biggest challenge is
Hmm.
maintaining. Sometimes operators get so big and
Hmm.
they have so many projects in so many different areas, it's easy to assume that you're going to treat each one the same, and you can't. So know your rules, know the city and the ordinances and the municipality that you're operating in. Consult with a lawyer if you're not capable or you're not comfortable doing it yourself.
100%.
And the most important thing, of all of it, hire, take care of, and maintain property managers, assistant property managers, and regional operators that are going to protect your business,
Hmm.
that are going to be your boots on the ground, and that they themselves will have the pride in their work to learn the laws for you so that you as an operator can be protected. But if you don't protect your PMs, if you don't protect your regionals, if you're not providing them with the tools that they need, um, it's going to hurt them. It's going to hurt you.
Yeah.
So treat them well, educate them, make sure that they are fully aware of what the rules are, and everything should be okay.
And well said. And I think, being in the industry for so long and, working side by side with you and your team in the past 5 years, which I had a great experience with, I think that one of the biggest challenges with the property managers is because exactly what you just said, you grow, the companies grow, and now they're taking that back seat and they're allowing their property managers to do this part of the legal, right?
Yeah.
And a wrong 3-day notice, a wrong amount, a wrong name, maybe a lease agreement that has the incorrect, a lot of property managers, careless mistakes, not using the legal entity, but rather, whatever the marketing property branded name is. And that is incorrect. So to your point, I fully support that. I think the leadership needs to understand the importance for them to have the right professionals in that seat and to educate them along the way, because we're evolving, we're changing, the laws are changing. And to your point, even when you said about the 30-day notice, I remember during COVID for specific, I think it was Freddie Mac or Fannie Mae,
Yep.
you couldn't post the 3-day notices. It had to be 30-day notices. And then there was base rent only. You couldn't add on any additional fees, whatever those fees were. So, you've got to be very careful. You want to make sure that, you're talking about legal risk here. And it's going to go, a lot further if you don't take the proper channels to do what you need to do.
Oh, it's going to be slower, more expensive.
Yep.
You're going to create a bad taste within the project, which you don't want to do, because that treating someone inappropriately or doing things incorrectly within a multifamily, it spreads.
Yes.
Tenants speak,
That's
and,
right.
and that can affect the reputation of the business itself. But it is, it's funny because you mentioned those moratoriums
Mm-hmm.
during COVID. Some of the laws that are still in fact, what was basically re-upped in Miami-Dade that I just mentioned
Mm-hmm.
stems from that moratorium.
Okay.
That moratorium essentially had a clause within it that it can be re-invoked in the event of a particular circumstance of which Miami-Dade County decided to use. Right. So
Wow.
it's one of those things where this is 2020.
Yep.
5 years later, we're
Here
still
we are.
dealing with it in a particular way in one county.
Yep.
Now, you go up to Broward County, Palm Beach County, Monroe, not the same. So be very specific, know where your project is, and become very, very knowledgeable about it.
And documentation. I think, myself mentoring my regional managers, property managers, and even working side by side with compliance, managers, documentation. Documentation is so important when you do those 7-day notices, 30-day notices, whatever violation notices or communications you're having with anyone, you need to have the proper timeline. It's so important. And sometimes property managers are so busy, Gabriel, that they say, okay, when I come in tomorrow, that's the first thing I do. And half of, maybe important key takeaways, they forget it. They're
Yeah.
human. They forget it and they didn't write it down. And that one note or that one time, piece of timeline would have been so important for you and your team to really support, moving forward on that case. So I think documentation is definitely, key to really voice that out there. Talking about keys and do's and don'ts, what would you share with do's and don'ts, moving forward to these on-site teams and these property managers and regional managers?
Yeah, I think you just touched on it. I think you hit the nail on the head. Documentation. You have to have your a house organized.
Mm-hmm.
Okay, and it starts from the first intake of that tenant all the way through the end of that tenancy. So having the proper intake, having the proper information about who the tenant is, getting copies of IDs, getting addresses, getting the addresses where they're coming from. Are they part of the military or not part of the military? Because as you know,
Really
in
important.
Florida, you have to submit an affidavit of non-military status when you're filing or serving a complaint on someone. So getting that information at the onset is very important. Making
Mhm.
sure that if there are other occupants, maybe they're not tenants, maybe they're dependents, maybe they're grandma and grandmother are not going to be on the lease, but they're going to be living there. You need to get their information because they need to be in the eventual eviction if, in fact, you get to that point, right?
Mhm.
So, documentation, getting the appropriate person, knowing who is my tenant. And in multifamily, it's a number sometimes, unfortunately. There's 250 units, 300 units. You need to move things along. You don't go into those details. The next step, lease. Have a proper lease. Make sure that the name on the lease of the landlord is the actual business name, the tax ID name, not
Mhm.
just the name that you're using in the industry. Okay, we had that issues in some of our projects.
We did.
Make sure you have the right address. Sometimes, if the building has a B or an A or a letter attached to it, to make sure that that postal address is the same as the address on the lease, that
Mhm.
there's a particular unit number. If you don't have the right unit number with the right tenant, your eviction is going to get dismissed right up, right about. Once you have the lease, you put everything in place. You make sure you discuss security deposits. Okay, whether you're going to take it or not take it, make sure that it's not going to be commingled. Okay, the security deposits in Florida need to be kept separate. If they're going to receive a fee or they're going to put a bond in lieu of the security deposit, it needs to be explained to them. It needs to be shown as an addendum or in a particular provision within the lease. And your lease, like everything else we discussed earlier, cannot be static.
Mhm.
It needs to evolve. It needs to adapt to whatever changes there are in that particular locale because it could affect the enforcement of that lease down the road. Okay. And then properly documenting, as you said, when the person moved in, when they actually moved their stuff in, did they pay everything before they moved in? We had a situation in Texas where someone moved in, never paid first month, never paid security deposit, moved other stuff in, never paid rent. And it was 4 months later when someone at the property management realized, uh-oh, this
We
person
dropped
just
the ball.
moved in.
Hmm.
The lease wasn't even countersigned by the owner, but the person moved in and all their stuff. And we have to go properly through the procedures in order to remove them. So having everything documented, doing a pre move in walkthrough.
Mhm.
This is the condition of the unit. This is how you're getting it. This is how I expect to receive it at the end. Have a checklist for that walkthrough. Have the tenant sign. Here's everything that you received and the condition in which you received it. So that at the end of the lease, whether it's through an eviction or whether it's just a natural termination of the lease, you do your final walkthrough and you have the one that you did when you first moved in. Now you have the second one, you sign that off, and now you have a complete document. And if you need to submit a claim or an intent to claim on the security deposit because there was more than excess wear and tear, you have the documentation to support it. You
Mhm.
have the ability to do it. And then again, follow the statute on doing that. You have
Mhm.
30 days from either the termination of the lease or from the last time that the the tenant lived in that particular unit
Mhm.
for you to send that notice, which must be sent via certified mail.
And that's one of the challenges that I think,
Where do you send it?
folks, yeah.
Right? So when you do that walkthrough at the end and they sign, hey, where are you moving to?
Where's your forwarding address?
What is your forwarding address? Exactly. Most people don't
Key
do that.
point.
And if you don't do it, you have nowhere to send it. And
Mhm.
I'm sorry, the statute is very specific. You don't send it by certified mail within 30 days. You waive your right to claim the security deposit. You have to return the
The
security
full
deposit
deposit.
to the tenant no matter what.
That's right.
Even if you do comply, they have 15 days to object. And
Mhm.
if they object, again, you have to return it. You have to make sure that you return the full amount because now you have to sue to get that security deposit back. Why? Because that's what the statute says. You
Yeah.
can't just keep it.
And talking a little bit about the security deposits and the refunds and the timeline. I know that stipulations, that's also something that's very challenging for the on-site teams, the assistant property managers, the property managers. They tend to, sign stipulations, and the stipulations, there's specific dates and specific amounts, and the amounts, the breakdown and the amounts that you have to include, the costs associated with what you're putting down and the lump sum, and the violations of the stipulations. You can't receive a payment, if the stipulation is outlining something different. And you have to make sure you contact your lawyer and the law firm. And in this case, if you're working with Gabriel's going to be available, and his team's going to be available to walk you through it. But it's extremely important. We can't emphasize enough the importance of the compliance part and how you're putting yourself out there, not really checking that off the way you should.
Yeah, absolutely. I mean, if you begin the eviction process and you've gotten to the point where someone comes up to you and are like, "Hey, listen, I really want to stay in the unit. I have the money. Can we get a deal done?" Right?
Mm-hmm.
And essentially, is how it works. They come up to you like, "Hey, here it is." And a lot of times, PMs, assistant PM, they want to help. They want to protect the family. They want to keep them there, and they end up entering into these oral agreements, which are not permitted.
Mm-hmm.
Once you begin the eviction process, there's a very specific process you have to go through. Once they've been served, the summons will tell the tenant very specifically, "Hey, any money needs to go directly to the court registry. It cannot go to them." Now, what we do, as you know, is, as you mentioned, the stipulation.
Mm-hmm.
Okay, you want to enter into a deal with us. You don't want to deposit the money into the court registry. You want your eviction to go away. Not a problem. But enter into a stipulation agreement, which then gets filed with the court. It's very detailed as to where the money's going, how much is being paid, when it's going to get paid, the conditions of possession. Okay, so if you breach any of these other monetary steps, then we're going to have the ability to move forward with the eviction. We're going to have the ability to move forward with it. And then once the stip is executed, it gets filed with the court. The next step is the most important. The property manager or the assistant property manager or the regional, whoever is handling it along with counsel, put those deadlines in a calendar, set reminders, invite the tenant to those calendar entries. It's
Mm-hmm.
their deadlines anyway.
Yep.
Right? Why spook them? At the end of the day, it's in everyone's interest to abide by that stipulation
That's right.
because it's a lot of stress and money to remove someone from a unit.
Mm-hmm.
So not only do you as a human not want to do that, you then as a business owner, you have the incentive to keep that person there, to keep them paying, to keep them happy. All right? And it starts with, "Hey, here's a reminder. You have 2 days to pay this." Just a reminder. And sometimes having those reminders are very powerful. They're
Mm-hmm.
very motivating, and people will find a way to comply because they know that you've gone out of your way as an operator or as a PM to keep them there,
That's
to
right.
keep a roof over their head. So, right? So you're creating goodwill, and it also helps you with other tenants and it helps you with those situations, but it doesn't work if you don't stay organized, if you don't keep it. Because the last thing you want to do is then say, "Hey, your deadline was yesterday, buddy.
Mm-hmm.
What happened?"
Mm-hmm.
"Oh, but why didn't you tell me the day before?" Right? That's a completely different conversation that you don't want to have. So be honest, be forthright, be organized, and for the most part, you'll be able to do it because it's in everyone's best interest to keep that unit there and to keep the exchange of funds flowing.
And I always, and that's great points, really great points. I used to tell the property managers all the time, plan, organize, execute, and keep the customer service, the resident satisfaction. You don't know what's happening with that resident. You don't know, what's taking them to that hardship, right? And at the end of the day, as you're representing the owner, you're the face of the company, you're the face of the investors. You want to make sure that whatever it is that you need to deliver, you're delivering that with transparency, professional, great customer service. Just because it's an eviction, it doesn't mean that you need to treat the person any differently.
Absolutely. I mean, from my perspective, multifamily operators, property management companies, you fall within hospitality.
Mm-hmm.
From my perspective, as a hospitality lawyer,
Agreed.
that's how I approach it. It's a service industry. You're there to provide a service on behalf of an owner, operator, for your tenants. Those are your clients. Those are those people that keep you employed, that keep the investors getting a return on their
On
investment.
their investments.
And
Absolutely.
people are going to be more likely to find a way to cure a breach
Hmm.
if they like you, if you've treated them well, if they're happy with the common areas, if they're happy with how the property management reaches out to them,
Hmm.
even organizing holiday parties and giving them one drink or one meal, it goes a long way to building very good, strong relationships with your tenants, which is what the hospitality industry is. You go back to a hotel, not because, well, sometimes because of where it's located, right? But a lot of times it's because the room was clean.
Experience.
The everything that, from the moment I walked in, I got
Hmm.
a free champagne or a free prosecco
Yep.
or a cookie,
Hmm.
right? I've showed up at a Holiday Inn at 11 p.m. and I have a hearing the next day. I'm starving. I didn't eat on the plane. That cookie, that cookie did
It
everything for
helped
me,
you.
and I'm gonna go back to that hotel because of it. It's just small little things that property managers don't think of themselves like that. They don't necessarily think of themselves as being within the hospitality industry, but you are,
But you are.
and
Absolutely.
it's a service you're providing.
And I think, and to your point, Gabriel, I think a lot of times, because we are in 2025 and there is great automation and AI tools, and we've got everything, and everything's moving along in such a fast pace. And we tend to forget that multifamily it's 100% people. It's all about people.
100%.
And if you forget that, you're trying to reinvent the wheel. And if you're trying to do that, you're forgetting the whole foundation of this industry.
Yeah, you're forgetting what industry you're in,
Correct.
because these aren't numbers
Yep.
in units. These are human beings. And so go out of your way as an operator to provide great customer service, to provide an experience in your
Mhm.
project, and your occupational rates are going to stay very high.
I agree from my own lessons learned and experienced. So, how would you say property owners prepare themselves to respond to litigation increase? Um,
Yeah, I mean, litigation is something that I think everyone wants to avoid, from ownership, property management, tenants. Even the lawyers in certain respects want to avoid litigation in certain cases, and definitely, doing evictions now for 6 years in three different states, it doesn't get any easier. I'm a husband. I'm a father of two.
mhm,
I know how hard it is sometimes to make sure that I make that mortgage payment. There's ups and downs for everyone,
mhm.
and it's when you go to a hearing and you have a mother there with her children, and all she wants to do is keep a roof over their heads. It's heartbreaking, and it doesn't make it any easier, because of the passage of time or how much they owe. It is a very difficult thing to do.
Mhm.
And so the best way to approach it is with respect,
Mhm.
with an understanding that you did, as an operator, everything that we have just talked about. You've kept your house in order. You've documented every single step. You have gone above and beyond to help them, to accommodate them, to provide them with a payment plan. And because you've taken all of those steps, you've kept the proper documentation. You've put the right information within your 3-day notice. You posted it correctly.
Mhm.
Okay. And if it's not a 3-day notice, it's a 15-day notice. If not
Very
15, a
important.
30-day notice, whatever the notice requirement is, right?
Mhm.
So, how to approach it, know what you're doing, have the documentation prepared and ready to go, have competent counsel that can really help you and provide you with these policies and procedures, best practices, right,
Mhm.
on how to begin that process and move through that process effectively, and be respectful. Be respectful of the process. Be respectful of what you're doing. It, they're not bad people.
Yep.
Their inability
They're
to
in a
pay,
bad situation, but perhaps not bad people.
perhaps not bad people. And you, as again someone within the service industry, you can't assume the worst. You have to assume the best. You have to assume that they're trying, and you have
Mhm.
to treat them that way until you're proven otherwise. Sometimes, unfortunately, right? But you make that effort. But it starts with everything that you said.
That's
I
right.
mean, I think you took the answer out of me. It's documentation, documentation, documentation. If you have the proper documentation, if you follow the rules and procedures, that is the best way of respecting the process,
Mm-hmm.
of providing them with due process, right? Their ability to defend themselves, and then your ability to represent your interest. Because at the end of the day, you have a job to do, and I have a job to do, and it's unfortunate. And I go up there and I'm in a hearing, and they call them trials, but it's really just an evidentiary hearing where you prove the case. And a lot of times you put the defendants on the stand and they're humble enough and honest enough to admit,
Yeah.
was there a breach in place? Yeah.
Yep.
Did you fail to pay? Yes.
Yes.
Do you have a substantial good cause reason not to pay? No.
Yeah. And then at that point, you got to move
That's it.
forward
You have to move
to your
forward.
to your point.
But if you didn't have the proper documentation, if you get to that hearing and you have the lease agreement in front of the individual and it has the wrong unit number,
Mm-hmm.
or it was not executed, or the numbers that you were charging for rent, your base rent should have been $1,000 and you were charging them $1,025. Well, now you've taken this person to trial. You've put an eviction on their record. You've got your case dismissed because the judge is going to be compelled to dismiss your case.
Mm-hmm.
You've wasted attorney's fees and cost. You've hurt someone, right? You've had to take someone out of their home. You have to put them in this courtroom.
Terrible experience.
Terrible
Terrible
experience.
reputation.
And you didn't do it right.
And you didn't do it right.
Right? And it starts from intake, lease, and documentation.
Yeah.
Keep your documentation in order, and you'll be able to respect the process and respect the individuals within it.
Great feedback. Great feedback. Thank you for that. So, share with us some insight into how you assist clients with corporate partnership agreements. I know that you dive into that as well, and I think our audience would like to know a little bit about that.
Yeah, absolutely. I mean, before you have the multifamily project, you have to have everything before, right? So that's what we talked about, helping our clients with the formation process. And so we assist investors, we assist operators, developers, construction companies to kind of put together all of the right pieces to form the right business entities to move a project forward. A lot of times the typical projects that we're talking about, the multifamily projects,
Mm-hmm.
are going to be joint venture agreements. The joint venture agreements are usually structured in a very specific way. So there's one LLC, limited liability company, that's going to be the owner of the land. There's typically two other entities that are going to be the owners or members of that LLC.
Mm-hmm.
And you create an operating agreement with a lot of times, at least in Miami, you'll have the developer and the GC on one side, you'll have your investors on the other, and they'll have an agreement together, either independently of the operating agreement, or sometimes, in one of our former mutual clients, not to say names, the way that they would do their JV agreements is essentially the owner, parent co,
Mm-hmm.
will be 50% owner of the single purpose entity that was created to own the land where the project is going to be developed. And then the other 50% or 40% is going to be investors and people that you bring in to invest in that project. And so the governing document that's going to govern the relationship between the parent co and the investors is going to be that operating agreement.
Okay.
And putting together that operating agreement is absolutely everything. It should take as much time as needed, and it should be as detailed as possible, especially if there's no mutual ownership between investors and parent co.
Very important document.
Very important. So that operating agreement for an LLC, if you're going to do an LLC, okay, if you do a corporation, which in Florida, it's not as common. There's a
Okay.
lot more corporate formalities that need to be followed. With an LLC, you have the same protection from liability for the owners
Mm-hmm.
and even for the managers of an LLC, but not the corporate formalities that the Florida corporation statutes have, right? So the operating agreement will discuss who owns what. We'll discuss your capital contributions, what money's being put in. It will discuss your distributions, how that money's going to come out.
Right.
And more importantly, I think, than anything is whether it's going to be a member managed or manager managed LLC. And a lot of times it's going to be a manager managed. And that manager managed part of the operating agreement is where you go into the details as to who's going to run this business and
And
what
how
it
they're going to run it.
and how they're going to run it, right? So a lot of times where the way they're structured is here are 10 things that the managers of the
Mm-hmm.
LLC can do without the approval of the owners or the members.
Mm-hmm.
And then you have, the material business decisions, taking out substantial loans, modifying the purpose of the business, selling the business or the assets of the business. Those things are going to require not just manager approval, but also member approval or ownership approval. And then what approval? 50%, right? A majority, a simple
Mm-hmm.
majority, super majority, 66.67%, or 75%, some people say, or unanimous, right? So that part of the document to me, I think, is where you spend the most time because those are the rules.
That's right.
And that is what's going to govern whether the managers are doing what they're supposed to do, whether the members are have been giving the rights that they have under the operating agreement, right? Because you want to invest in something, you want to put money in something, you need to know not just your ROI, but what control am I going to have? What ability am I going to have to vote to say, yes, this is a good idea, no, this is a bad idea? All right, so that operating agreement and taking the time to go detail. Don't just use an operating agreement that you've used before.
Mm-hmm.
Take the time. Be aware of the locale. Be aware of where you are, the state, municipality, the city. Be aware of your investors. Are they foreign investors? Are they all domestic investors? Okay, because that may change some aspects of your operating agreement. Make sure that they're each represented by their own counsel. Sometimes I've been in the position where it's like, hey, just represent us both. You help us here, you've helped us. The investors, I've helped you guys in certain respects. The owner,
Mm-hmm.
I'm their counsel. We're all friends. No, we're not all friends.
No.
We always start as friends, but it may not always end up that way. So it's very important that each side has their own counsel, that they're all independently represented, that they understand the operating agreement, because that's going to be the document that's going to govern their relationship from inception until sale.
That's right.
Right. And then going in through those specific provisions on sale and how that's going to work.
Mm-hmm.
And who has the ability to say, okay, the project is ready to be sold.
And
Right.
the importance of sharing this list with the property manager and the regional manager for them to also understand those rules and regulations and why whether it's weekly reports, whether it's capital projects, whatever it has to do with the operational side where they're obviously very involved overseeing the asset day to day, they need to be aware of that list.
Oh,
So
absolutely.
I think
And
that
even
needs to
more,
also be shared.
right before the sale, that due diligence checklist,
Hmm. That needs to be
that needs to be
circulated.
circulated. Okay. Because those that are going to be boots on the ground, that are going to be making sure that there's no material change in the business, which is part of every single LOI when you go buy an asset like this. You don't want any material changes to happen. But who can affect that? So when we talked about managers in the LLC, it's not the same thing as PM. So just for the audience to be very clear. So in an LLC, the owners, right, are members. In a corporation, they're called shareholders. In an LLC, your officers, those that govern the day-to-day operations of the business are your managers in a manager managed LLC. So that is what we would call the upper level, your C-suite, your executives of
Hmm.
the business. And then you have below them, the managers will then hire a property manager, a assistant property manager, a regional property manager if it's part of a lot of projects within the area. And those managers, not the managers of the LLC themselves, but the manager that you hired that is going to have their people on the ground doing the intakes, doing the leases, making sure that the occupancy rates stay high, making sure that the evictions are being processed, making sure that we're collecting, that we're putting the proper notifications on time. Those managers are the managers that you and I are discussing when it comes to those due diligence checklists,
Yep.
because they control the individual operations of the business,
The day to day.
that day to day. And
The
that day
day
to
to day.
day is when it transfer hands has to be smooth.
Yep.
And the best way to have it smooth is to have, we've said this like 7 times already in this podcast, have your house in order. Document, document,
Documentation.
document.
Yep.
So it's extremely important. And yeah, so I think we strayed a little bit away from the original question, but yeah, formation, organizing, and having that operating agreement to be as exacting and as specific as possible, so that there is no vagueness, there's no leave it up to interpretation or let a judge decide what this provision means. No,
Hmm.
take the time, do it right, get mutual assent, and that business relationship will hopefully move forward in a very, very mutually advantageous
And
way.
I think if there's plan and organization and documentation, there's no reason why you shouldn't, right?
Yeah.
Um, for the most part, at least.
Yeah, for the most
Saying
part,
that.
right? Unless we have another COVID hit and then,
Correct.
right?
And
But
then
if,
it's something totally
then we'll
different.
see.
Yes. So let's talk a little bit about vendor contracts. I know that you do that as well. And what would you say is the red flags that you often see in vendor contracts, whether it's, for new developments or a stabilized asset already and it's something that's operational?
Yeah, so the one thing that, I can go into vendor contracts for another 3 hours, so I won't do that. But I think to just be very specific about the red flags for me, and one of the things that we focus on very early on in the negotiations is the ability to terminate either with cause or with convenience. You know, there's a lot of times where you don't really know if what you're getting in exchange for this vendor agreement is the quality that you expect.
Hmm.
It is the level of attention that you expect from that particular vendor. And at the end, as we've said, we're in the service industry and we need to make sure that we keep the bar high. And if a vendor is preventing us because of poor quality of goods or poor quality of service from reaching that bar, we have to be able to get out. And a lot of times, what you'll see in these vendor contracts is initial term 1 year. And within that year, it doesn't matter if they fail, if their quality is terrible, you're stuck with them with that year. And you can't terminate unless it's for cause. And look, just because I don't like the product or it doesn't meet my expectations doesn't necessarily rise to a for cause termination.
Good
And
point.
that's the problem.
Hmm.
So, yes, you'll have a 1 year initial term with a 30-day for cause termination provision, but it could, maybe they met every single condition, but just what we're getting is not good enough. And I
Hmm.
don't want to have to give this to my constituents, to my tenants, to the
Hmm.
people that I am serving for a year because I didn't do my job as a lawyer and you didn't do your job as the regional or PM of a particular project by negotiating the ability to get out
Yeah. The
for
due
convenience.
diligence from the beginning.
Just get out
Hmm.
because ultimately having that ability to do it is great. Now, there are some vendors, your AT&Ts, the ones that require infrastructure, that require cabling, that require a massive amount of expenses on the vendor side to provide you the service. Those likely you're not going to be able to get a convenience provision, okay, because of the amount of expenses that they have to incur just to provide you that service. And I think that's reasonable. But in those situations, you know what you're getting for the most part, right? We're talking about other vendor contracts where it's not that capital intensive for them
Hmm.
to provide you with the services or the goods. And so you want to be able to negotiate the ability to terminate on convenience or for a cause within 30-day notice. That to me is key. And you got to start there. Obviously, you want to be reasonable, like I said, with these other, your AT&T or your bigger infrastructure contracts, but everything else, focus on that. And then the second red flag, prevailing attorney's fees provision. There's going to be a dispute amongst this contract. You're going to say you provided the services, and I'm going to say you didn't provide me the services adequately, and we're going to litigate. I want to make sure that my attorney's fees and costs are going to come back to me if I prevail. So you want a mutual prevailing attorney's cost provision within your agreement, and you want a solid termination clause in your provisions within your provisions that allow you to get out for convenience and or for cause.
Okay. Good
Red
stuff.
flags.
Yeah, great stuff. Great stuff. So, from your experience, which is great experience, how can multifamily teams better protect themselves from potential legal risk? And I know that we've kind of touched that throughout, the episode today. But anything, from trends or developments that you're seeing that operators should be prepared for today.
Yeah, I think we're seeing, and we touched on this a little bit, we're
Mm-hmm.
seeing a lot of changes specifically in the multifamily sectors and in your residential sectors of laws being developed by municipalities to protect residences. So they're adopting and they're bringing back, as we mentioned before, Miami-Dade County has decided to bring back, this part of that moratorium in the 30-day notice. And a lot of individuals, including myself,
Mm-hmm.
in a county in Texas, which is where it happened. And then we started doing our due diligence in Miami. We were able to figure out that in Miami, they just recently did this as well. We just didn't have the opportunity to have a situation specifically for our clients where we would know that. But that kind of sparked that need to have a continual thumb over the pulse of what's going on in your locale. Be involved. There are a lot of meetings that are being held within the industry. There are a lot of newsletters. There's business journals. There's lawyers that we have the obligation to have certain subscriptions to different magazines and different editorials that provide us with these kind of updates.
Mm-hmm.
The Florida Bar also provides some of these updates, specific subsections of the Florida Bar. So if you're real estate subsections or others, they provide you with a lot of this information. There's a lot of really good law firms out there who have editorial boards that continually on a weekly basis put out a lot of this information. So whether it's you, the business, trying to keep your own thumb on the pulse of what's going on in the locality where your projects are located,
Mm-hmm.
or you have a lawyer that's doing it for you, I think that is extremely important to get ahead and to prevent changes in fair housing, to prevent changes in ADA. One of the things we're seeing now is ADA lawsuits for website.
Mm.
So you are providing a website for individuals to go and pay rent. But that website is not ADA compliant, and someone who cannot see or someone that has another disability, and
Huge red flag.
your website isn't compatible and they can't pay rent, and they're obligated to somehow figure out to get you a cashier's check and pay you at that. That's going to be a tremendous lawsuit, and it has been. It already started. So we're seeing a lot of ADA website-related lawsuits being filed because the websites aren't compliant. And just, by the way, just putting the little blue thing at the bottom of your website, that's not ADA compliant.
No.
If you can't click on it, if it's not reading your website for you, if it's not doing the things that it should do, and there's some really good plugins that you can do, and some of them are free, some of them you pay for. It has enhanced services, but a lot of times your e-commerce website or Shopify or whatever it is that you use to collect the funds, they themselves have really good handicap tools that allow you to adapt that and put those plugins into your webpage to prevent any potential lawsuits, and more specifically to prevent you from discriminating against someone who doesn't have the ability to necessarily read a website or access it in a way that that is common.
Mm-hmm.
And so you want to be very specific about that. So I think it's impossible to prevent litigation, but you can definitely take steps to put yourself in the best position. And we've talked about those already.
Well said.
Keeping your house organized, proper documentation, knowing the rules and the laws within the municipalities and the cities that you and your projects are in, maintaining yourself informed, whether it's editorials, whether it's, you know, South Florida Business Journal, whatever it is that you can get yourself informed. Don't just assume that it's all going to stay the same. It's not.
It's not.
Okay.
And I could definitely say, myself with my team, one of the things that I found extremely important and beneficial to the property managers, and sometimes to the assistant property managers and the leasing agents, as the quarterly meetings. In the quarterly meetings, you need to discuss this. This is something that you need to talk about. You need to make space for legal and have Gabriel and his team come on board, and share with you this piece of information. It's going to go a long way. You can't just focus on service animals and, fair housing. Yes, those are keys and they're important. And most operators tend to use either in-house, online classes, maybe through Grace Hill, and keep that compliance part. But it's so important to also understand this portion of the legal side. It is extremely important. We can't even emphasize enough. As you stated, we could go hours and hours talking about that.
Yeah. Well, I mean, whether it's our firm, whether it's any firm, in whatever jurisdiction you're in, be informed. We did, with our mutual client, um, we did seminars,
That's
right?
right.
And we had those annual seminars, and we had all the PMs and all the assistant PMs get together and had a PowerPoint presentation, and we had them
Hmm.
take pop-up quizzes, and we gave them a certificate at the end because it's important.
It is.
And it's important for them, it's important for the owners, it's important also for the law firms, and to make sure that we're all in the same motivational path of we need to ensure absolute compliance. We need to ensure that we're doing everything right. And there's change, and you have to stay with the change. And there's change in personnel, and
Hmm.
they need to be brought in and they need to be educated. So it's a continual wheel of knowledge that needs to continue to roll down the path of the life of a project,
Yep.
and that wheel can never stop until you sell. And then
Until
once you sell, it's somebody else's problem, right?
that's right. That's right.
But while you still have it, while that project is still there, you want to make sure that you're continuing that knowledge cycle continuing.
Yep. And what's one piece of legal advice you think every property manager or regional operator should know? And I know this could go so many ways when you answer this, but just for the audience to take that with them today.
Yeah, I mean, oh man, we've covered a lot of those takeaways today. It's really hard to point into one specifically, but what I would say is, of all the points we discussed, the easiest point, and one that has legal ramifications, as we've discussed already, for the life of that agreement, for the life of that tenancy, is know your lease.
Hmm.
Sometimes the individual agents that are putting the lease in front of the tenants, they've never read the lease before.
They
Blue
just
Moon does a
initialed and signed off because they
exactly.
need to move in.
Blue Moon does a pretty good job of staying up to date, of modifying and updating its leases depending on where that project is located, but they're very long
Hmm.
and they have a lot of addendums. So my piece of advice is, owner, property manager, regional, know your lease for the particular project that you're in, and go through it.
Hmm.
Make sure you have the proper name of spelling of the business owner, not just the DBA name, not your service name, not the name that you wish the project to go by, the actual name of the owner, which you can check on Sunbiz. The tenants' names as written in their licenses, okay? The proper address and the proper amounts for rent.
And when we touch on the proper addresses, let's remind the property managers and the on-site teams, it's not going to be F210. That's not the
That's
proper
not the proper
address.
address. It's your
So
postal
that's a
address.
great example.
Yeah. And so the better the PMs know the lease, the more thorough they can check the accuracy of that lease, And the better they know their rights as representative of the owner, and they should also know the rights of the tenant.
Mm-hmm.
Because a tenant will come in and say, under the lease, I have the right to do this. And a lot of times, the people who's receiving that demand has absolutely no idea if that's true or not.
Mm-hmm.
And what do? They go based on instinct, or they go, you know, machismo, or they go with, oh, I'm the boss. No,
That's not the way it
that's
works.
not the way it works.
No.
I'm a lawyer. And so from me, obviously, this is what I'm going to say. But to me, what is written is what is done.
It's what it is.
That's it.
Yep.
And so you need to know what's on that page as well as the owner. You, the property manager, needs to know what's on that page as well as the owner, as well as the lawyer, as well as the tenant.
Mm-hmm.
Because as you said, you are the face. You are the representative of an entire network that's behind you. And it is your responsibility to ensure compliance
Mm-hmm.
and to ensure that the goodwill of that owner and of that business continues.
Yeah.
And one person can make a big difference.
That's right. That's right. Well, before we go today, I want to make sure that I know it's very important and it's something that's it's very popular here in Florida. Florida Live Local Act. And any current existing lease agreements, and maybe that asset has decided that they are going to roll this program out and they want to be part of this program, and they have to amend these lease agreements, whether it's upon renewal or during the lease term. Um, do you and your team also assist with this process?
Yeah, absolutely.
Okay,
And
great.
we definitely, we'll walk you through the process of doing that. Now, you have to be very conscientious as the operator and PM who drafts these leases.
Mm-hmm.
Because a lot of times, if you're really that embedded with Blue Moon, I just use that as an example off the top of my head, but there are other companies like that that have these very formalistic leases. Those changes will be incited by the firm or by the client, but it will ultimately be done through their organization because they need to make it uniform throughout. The other option is simply just get out of using those formalistic leases and just
Right.
have your lawyers draft your own leases, and then we can modify and make those changes very easily.
Okay.
But if you're using those others, so that's the caveat, I guess, to the response is we can initiate, we can instruct, but ultimately the actual changes will be made through a company like Blue Moon if you're using their forms. And I know that
Great.
our mutual client, does use them and uses them in Florida, Georgia, and Texas.
Mm-hmm.
And we've had an issue recently where we've had to modify Texas a little bit,
Okay.
and we had to go through the board of that company in order to approve it because it then had to use, based on its own internal policies, that change for every single other project, not just our
Okay.
client.
Oh, wow.
So it has ramifications when you're submitting those substantial changes, but it can be done, and we would most certainly love and welcome the privilege to assist in that way.
Great. Well, I'll make sure to share with you all Gabriel's information and any questions that you may have, and you need a team to support you during your day-to-day operations, whether it's a new acquisition, a corporate agreement, contract, a vendor management, anything, you name it, him and his team will take care of you. And thank you, Gabriel. Thank you for all the great insight, the valuable insights that you've shared with us today. I think our listeners are really appreciating the great feedback that we've gotten from you today. So thank you for joining us.
No, thank you, and thank you for having me. And they're right. You're fantastic at this. So it's been a privilege to be here, and I absolutely love it. And let's work together. Let's continue to do that. Right.
You got it. Thank you.